The International Covenant on Civil and Political Rights, which was brought into existence in March of 1976. Article 8. This is a natural right, a fundamental right that has been recognized. It says, no one shall be held in slavery. Slavery and the slave trade in all their forms shall be prohibited. Subsection 2. No one shall be held in servitude. The International Covenant on Civil and Political Rights, Article 2.2. It says, where not already provided for by existing legislative or other measures, each state party to the present covenant undertakes to take the necessary steps in accordance with its constitutional process and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to the rights recognized in the present covenant. So we saw in Article 8.2 where it said, no one shall be held in slavery and no one shall be held in servitude. And now the covenant says that fundamental right, that human right, that natural right has to be brought forth in domestic law through, it says, the constitutional process. But the qualification says we're not already provided for. So if the right already exists in the domestic law, they don't have to create a new law. They don't have to transfer the right because it's already existing in their domestic law. So let us look at the United States of America, for example. We're looking into the Constitution Act of America, the additional amendments that were attached to the original Constitution Act. We're looking at Article 13 right now. If you will look, it says that this article of law was proposed in 1865 and it was ratified in 1865. It was accepted in 1865. Now watch what the law reads. It says, neither slavery nor involuntary servitude, except as a punishment for crime, whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Congress shall have power to enforce this article by appropriate legislation. So in the United States of America, within the Constitution Act of America, there was already the right not to be held in servitude and not to be held in slavery, recognized in America since 1865. The International Covenants on Civil and Political Right recognized this natural right, this fundamental right, in 1976. And it said that all territories, all state parties that would now become a member to the International Covenant, that would become a signatory to the International Covenant, would have to recognize this right. And if on their domestic territory, this right of not being held in servitude or slavery was not in operation, then they had the obligation to create a law, to create an article of law that would bring forth this right through their domestic laws. However, as you see here in America, they already had this law in operation. So they didn't have to create a new law in order to have the mechanism to express that no one shall be held in servitude. When you look in Canada or when you look in Russia, this law was not already recognized. We had to bring it forth through the Constitution Acts directly. So that's why when you look back into the International Covenant, it makes a qualification. It says, we're not already provided for by existing domestic laws. And I'm paraphrasing. We're not already provided for by domestic legislation, which is domestic laws. The state party, America, Russia, or Canada, must transfer the right into the Constitution Act or provide a measure to exercise the right. But yet here we see with America, the right had already existed prior to the international covenants. In the Constitution Act of America, the amendments to the Constitution Act, Article 14, you find the following. It says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now, this is teaching you a few things, but two important things. is that first you're considered a citizen of the United States. And as a citizen of the United States, you are under the control of your head of the state, your executive power, which would be the office of the presidency. And secondarily, you can exercise your right as a citizen of your state, a state citizen. And thereby, you'd be under the control of your local governor, your governor of your state, depending upon what capacity or designation you choose to stand under. However, you never want to take the designation of citizen, because a citizen is a subject and a servant of a sovereign, whether it's your state through the Governor General, or whether it's through the executive powers, the head of the United States, through the office of the presidency. The Constitution Act of America, Article 2. You see, it states, the executive power shall be vested in the President of the United States of America. He shall hold his office during the term of 4 years, and, together with the Vice President, chosen for the same term, be elected as follows. So the executive power, the head of a state, the ruling power, is vested or placed in the office of the President in the United States of America. Compared to Canada, you see where it says the executive government and authority of and over Canada is hereby declared to continue and be vested in the Queen. So in America, the President is the sovereign, and in Canada, it is the Queen, Her Majesty, the Queen Elizabeth, who is the sovereign. If you were to look to Russia, it's declared through their Constitution Act that the President is the sovereign. So each country has their sovereign, and this sovereign is supposed to be the head, and as citizens, we are subjected to this sovereign. When you're looking in the United States of America, the United States Constitution, Article 6, Section 2 of the U.S. Constitution is known as the Supremacy Clause, because it provides that the Constitution and the laws of the United States shall be the supreme law of the land. It means that the federal government, in exercising any of the powers enumerated in the Constitution, must prevail over any conflicting or inconsistent state exercise of power. So here we're seeing that the Constitution is known as the supreme law of the land in the United States of America. The Constitution of Russia, Article 4, subsection 2. The Constitution of the Russian Federation and federal laws shall have supremacy in the whole territory of the Russian Federation. We see the same mechanism of law playing out here in Canada. When we look into the Constitution Act of Canada 1982, Article 52, it states the Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect. So we have this same operation of law playing out in the United States of America. It plays out within the Russian Federation. It plays out within the New Zealand territory. It plays out on the UK territory. It plays out here on Canada's territory. Any state or any country that signed on to the international covenants, their constitution after became the supreme law of the land. Their constitution had to express the fundamental rights and freedoms that were brought forth within the international covenants. We're looking at the Interpretation Act of Canada. They have interpretation acts of each province, but we're looking at the one in Canada. Now here in Article 4, it talks about the enacting clause. The enacting clause of an act may be in the following form. Her Majesty, by and with the advice and consent of the Senate and House of Commons of Canada, enacts as follows. The enacting clause of an act shall follow the preamble. So it creates an obligation here. Since they use the word shall, this creates an obligation. It shall follow the preamble, if any, and the various provisions within the purview of the body of the act shall follow a concise and enunciative form. So once they create an enactment, a regulation, once they write the preamble of the enactment, right after that, there should be an enacting clause here. It says Her Majesty, who we know is the sovereign, who is the head of the state, who has the power, and we are her citizens, It should say that she gives it or she enacts it. As you see, Her Majesty, by and with the advice and consent of the Senate and House of Commons of Canada, enacts as follows. Then the enactment is considered to be given royal assent. It's be considered law in Canada, legal law, and official law. So if an enactment or regulation is created and you don't see this enacting clause here in the enactment, then it means Her Majesty did not give it royal assent. Her Majesty did not make it a law here in Canada. Okay, we're looking at the Canadian Revenue Agency enactment. This is an enactment that created the equivalent to the IRS here in Canada. The one who collects taxation here in Canada. This is the corporation. This is the agency that does it. This is the enactment that created the agency itself. Now, when you look at the enactment, you see what you find here. It says, an act to continue the Canada Revenue Agency and to amend and repeal other acts as a consequence. Now, we find the enacting clause. Her Majesty, by and with the advice and consent of the Senate and House of Commons, enacts as follows. So in law, we see that Her Majesty, who is the sovereign, who is the head of this state, has enacted this law. She has given it force of law. It is legal in operation in Canada. It has force of law in Canada. Now, when you look to the Citizenship Act here in Canada, the enactment, the regulation that creates the duties or obligations of the citizen, you see that you do not find an enactment clause. You do not find royal assent. It says an act respecting citizenship, and then it goes into the short title. This act may be cited as a Citizenship Act. So Her Majesty did not give this royal assent. There's no enacting clause in the Citizenship Act. This would be considered a de facto power. This would be considered a de facto enactment. Why? Because Her Majesty did not give it royal assent. This is the Criminal Code of Canada, Article 15, and it says obedience to de facto law. No person shall be convicted of an offense in respect of an act or omission in obedience to the laws for the time being made and enforced by persons in de facto possession of the sovereign power in and over the place where the act or omission occurs. Let me try and translate this into modern English, or easily or better understood English, excuse me. What it's saying here is that if the enactment has not been given royal assent, as I have shown you, the assenting clause, if Her Majesty didn't give it royal assent, it means Her Majesty didn't say, yes, this law can operate here on the territory. Therefore, the persons who are taking duties and operating powers from those enactments are in de facto possession of her power, of the sovereign's power. They're operating these powers even though Her Majesty did not say they could. So when you looked at the CRA, the Canada Revenue Agency, Her Majesty created and gave royal assent to that enactment, so that power can operate. But when you look to the Citizenship Enactment, Her Majesty did not give it royal assent. There's many enactments that Her Majesty did not give royal assent, and therefore the ones who are occupying these offices and drawing their duties and responsibilities from these enactments are de facto powers. The sovereign, Her Majesty, did not say, yes, you can do this. Therefore, if you and I fail to obey these laws, whatever they may be, we cannot be held responsible. We cannot be charged for them because Her Majesty did not give them royal assent. And that would only be under the position of citizen, of subject to Her Majesty. You see, they clearly know what they're doing. Why didn't they give the Citizenship Enactment royal assent? If they gave it royal assent, that would mean that we, as individuals, are being held what? In servitude, under an oath to a sovereign. And that would be against international law. And that would be against the obligations that the head of this state and the state of America and the state of Russia and the state of New Zealand and the state of Great Britain and the state of the United Kingdom and all those who signed onto the covenant, it would be against their promise and against their obligation to the covenant. That's why, when you look here in Canada, Her Majesty didn't give it royal assent, not to breach her obligation. Remember, Article 5 of the covenant says nothing in the present covenant may be interpreted as implying for any state, group, or person, Her Majesty, the sovereign, the office of the presidency, any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms recognized herein, or at their limitation to a greater extent than is provided for in the present covenant. Article 8 states clearly that no one shall be held in slavery and no one shall be held in servitude. If the citizenship enactment was given royal assent, then that would mean that legally, through this operation of law, we are being held in servitude to Her Majesty, which would be against international law, which would place Her Majesty against her obligations. And same thing for the United States of America, and same thing for the Russian Federation and all these other nations. This is the oath they would want to say that we're held under. I swear or affirm that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II, Queen of Canada, her heirs and successors, and that I will faithfully observe the laws of Canada and fulfill my duties as a Canadian citizen. So they're trying to say that we're being held under allegiance to Her Majesty the Queen, and then you'll get some judges here in Canada who will try and say, oh, no, it's not really an oath to the Queen, it's an oath to an idea. And then you got those other judges who will say, no, it's really an oath to the Queen, because she's an individual and she's the sovereign. Because we find out in the Constitution Act of Canada 1867, Article 9, that is indeed the Queen Elizabeth II, a real living individual who is the head of the state, who has the executive powers. And here we find we're being forced to swear an allegiance to her, which would put us into servitude, which would break her obligation to the international covenant. That's why they don't put this citizenship enactment or regulation into royal assent. They don't put the enacting clause, because then she would be creating a tort against us. This is one of the major mechanisms of law that they use to bind up the persons here. So in the citizenship enactment, status of persons in Canada, citizen of the Commonwealth, every person who, under an enactment of a Commonwealth country other than Canada, is a citizen or national of that country, has in Canada the status of a citizen of the Commonwealth. British subject, for the purpose of any law enforced in Canada on and after February 15th, 1977, that refers to the status of British subject, the status so described shall refer to the status of Canadian citizen or citizen of the Commonwealth, or both, as the intent of that law may require. Now, this hasn't been given royal assent, but if you understand what's being declared here and the mechanism that they're using here, it's horrible. Placing everyone into servitude. Why? Well, it's a Commonwealth, right? Her Majesty is what? She's the ruler of all the Commonwealth nation. And here she's bringing forth her powers.